I would like to call upon Professor Dr. Mark James. He's a legal scholar with a specialization in sports law and Olympic law. He currently serves as a director of research at Manchester Law School, a position he took up in 2016. With a rich academic career spanning over 2 decades, Professor James has made significant contributions to the field of sports law. His expertise is showcased through his diverse body of work, including books like Olympic Laws, Culture, Values, Tensions, and Sports Law, which have added depth to the understanding of legal issues in the world of sports. Professor James has also supervised numerous PhD students, fostering research on topics such as football banning orders, badminton governance, and copyright protection for literary characters. Over to you, sir.
Thank you for inviting me here today. Thank you to Professor Varyath, colleagues and students, and in particular to Mr. Negri and Mr. Subramaniam for inviting me here today. It is a pleasure and a privilege to be able to speak with you on this first certificate of sports law in India about what sports law is and really why we're all here today. When I first began working in this area in 1994, it was now, so nearly 30 years ago, there was no provision of sports law in the United Kingdom. And when I was applying to find places to do my PhD, which was about consent and injury on the sports field, I was told by several institutions that sport was not an appropriate context for the study of law. We've come quite a long way in 30 years, and I'm now lucky enough to have been involved with a number of firsts in the UK and in Europe, including helping to write the first sports law undergraduate unit, run the first Masters in Sports Law, contributed to a number of books, and am now a professor of sports law and the editor-in-chief of the International Sports Law Journal, all things that were almost impossible to have imagined 30 years ago when I started out. In this introductory session, I will take you through some of the key definitions, concepts, and milestones that will hopefully make your journey through this certificate as interesting and understandable as possible. In particular, I will talk through some of the key definitions that you will need to understand. What is sports law? Should we be calling it sport and the law? What is lex sportiva? All of these things are essential to understand, to be able to work through what it is that we're actually talking about here. Although there are advocates for each of those terms, they are really quite different. Some say it doesn't matter at all, and we'll come back to those working definitions in a few minutes' time. But what is important to take into account is that, in my opinion, there is an underpinning thread to all of the areas that you will be looking at this week. And that, put quite simply, is that sport is special. It is different where the law is concerned, and it needs the law to adjust its focus to ensure that both sport and the law work properly. So throughout most of what I'll talk about today, I will be calling it sports law rather than sport and the law, and more on lex sportiva and what that is later. This idea of the specificity of sport is something that is becoming acknowledged increasingly within the sports law world and has been driven by a number of cases that have gone through the European Union courts. And what we mean by this concept of specificity is that we have to take into consideration these special characteristics of sport, those that need protecting to enable sport to operate and continue in the ways that we know and enjoy. After all, sport is a different sort of business, whereas one business might want to put out of business every other competitor. If you do that in sport, you have nobody to play against. So we have to make sure that the law is accommodating for what sport is. So we'll look at issues around competition law that allow sports governing bodies and international federations to act as monopolies. We'll look at consent and combat sports and how without changes to the law on consent, we can't have fighting sports. We'll look at issues around employment law that have allowed transfer systems to evolve, which would be illegal in any other context. We'll touch on issues of discrimination that allow age group or international competitions, which would usually be illegal. And we'll look at privacy and the changes to the law that need to be undertaken to ensure that doping control is allowed. But these exceptions are limited, they are conditional, and many people have talked about the idea of conditional autonomy of sport. That is, that sport should be treated differently, but it must still remember that it has to adhere to the law in general. So we can prevent unauthorised or breakaway leagues, but we must have a structure by which these new alternative competitions can apply to be recognised. We might be allowed to have fighting sports, but we're not allowed to have death matches where people fight until the opponent is killed. And we cannot unreasonably restrain a player's right to seek employment at an alternative employer. And this conditionality and this specificity will underpin everything that you look at this week. That sport is special, it should be treated differently, but it has to do so within a framework that is provided by the law. So, who are the stakeholders in sports law? Who are those who are affected by it? Who are those who need to resort to sports law? Well, sports law has come a very long way in a fairly short period of time, and it means different things to different people. But the kind of images that we've got on the screen now demonstrate who is most likely to bring a case in a sports law action, but also who is likely to be the defendant in a sports law case. On the left, you can see three athletes who have been instrumental in the way that the sports law has developed. At the top, Caster Semenya, whose recent challenge was accepted to the rules of World Athletics that were preventing her from competing because of changes that World Athletics had introduced to their rules on who is a woman as far as athletics is concerned. And Caster Semenya's case builds on that of Dutee Chand, who many years ago went through similar processes to try and have the rules changed. As we'll see later, Semenya has sort of won her case, but it has meant that we now have to ensure that athletes' human rights are respected in everything that they do in respect of sport. The footballer is somebody who probably nobody here will recognise, but who is potentially the most famous sports law footballer ever, Jean-Marc Bosman, the Belgian player who challenged the transfer system in Europe and who ultimately won his case to demonstrate that athletes should be allowed freedom of movement as protected by European law. We then have the challengers to the normal order and governance of sport by groups like the European Super League, who were trying to create an alternative competition that would be set within that already run by UEFA and further by FIFA. The latest version of the European Super League has ensured that, yes, it is possible to run an event alongside those that are run by the official bodies, but you must bear in mind the rules of those governing bodies. And we'll come back to this a little bit later. But the European Super League breakaway is nothing new. This was first seen in British Rugby Union over 130 years ago when Rugby League decided it wanted to break away from Rugby Union and be able to pay players for performing. So we're really just building on some of these things that have been around a very long time, or we're applying traditional notions of what the law is to sport. We've got the Tokyo 2020 emblem up there as well to demonstrate the importance of major international organizations in the governance of sport, and in particular how they protect their income streams. In the bottom right, we have three people, a fan, a commentator, and a reporter, all of whom were challenged by the Qatari authorities for promoting LGBTQ rights at the FIFA World Cup, to show that free speech and national culture often clash in these highly emotive and political environments in which sport takes place. And we also need to remember the fans and their role in all of this. And what you've got there is a group of Liverpool fans who are bringing an action against UEFA, the governing body for sport in Europe, because of their mismanagement of the Champions League final last year, at which a number of Liverpool fans were crushed when they were trying to gain entry to the stadium. So all of these groups, all of these people are relevant stakeholders when we come to looking at what is sports law and who needs to use it. So how did we get to where we are now? What is sports law and what does it mean? Well, as I mentioned at the start, we need to have some working definitions of what sports law is before we go any further, because it is actually quite important to get these terms right. Most people who work in sports law and most sports lawyers are quite sloppy in the way that they use these terms, often interchangeably. They will mix and match, use whatever they feel is appropriate. And usually what everybody talks about is sports law. However, what I think is important to bear in mind when we're looking at the different cases and the different rules and how they apply is to ensure that we actually have the very specific meanings of these terms clear before we get going. So lex sportiva is a term that you will come across a lot when looking in particular at international sports law. Lex sportiva is really the internal rules of a sport. It's the rules that are defined by the International Sports Federation and applied by the national governing bodies. It's how a sport is governed. And in reality, it's simply a network of contracts that link each of the organisations in the pyramid that governs most sports. So you'd have your international federation at the top, underneath that the continental associations, then the national governing bodies, and then the clubs, leagues and players underneath that. In each of their contracts will be something which says that they must adhere to the rules of the body above them in the sports governance pyramid. Usually the Court of Arbitration for Sport will sit at the top of most of these issues as the key body that is in place to determine how, when and why sports law applies to any given incident or disciplinary process. Now, lex sportiva then, as the internal rules, can be contrasted with sports law, which are the national, international and sometimes transnational laws that apply to sport. These are either general or sport-specific rules that we would traditionally understand as being sports law, being law, and the way that they apply to sport. And I'll come back with some examples on these on the next slide. Two other areas that are becoming increasingly important are lex olympica and Olympic law. Because of the power of the IOC and its ability to utilize its commercial and political leverage to force its will in many ways onto the hosts of the Olympic Games. So lex olympica is very similar to lex sportiva. It is the legal norms that govern the International Olympic Committee and the entire Olympic movement. So lex olympica occupies this rather unusual position in our discussions, because in reality it is both a subset of lex sportiva, but also it is a real driver of lex sportiva. Wherever Lex Olympica goes, sports law or Lex Sportiva will often follow. And then finally, Olympic law. This is important because it's a highly unusual form of law that is usually forced onto hosts by the International Olympic Committee and demonstrates really the power of the IOC and its ability to create law in its favour. Obviously, the IOC is not a nation state under normal circumstances. It does not have direct lawmaking capabilities. But what we'll see shortly is how the IOC can create law in the host jurisdictions. The reason why Lex Olympica and Olympic law are important, as I mentioned, is because they often drive Lex Sportiva and sports law. And it's really only the IOC that is able to do this. FIFA, the world governing body for football, often tries to do this and is successful to some extent, but no other major sports organisation has been able to achieve the levels of governance and legal creativity that the IOC has been able to. So where do all these different sorts of law come from? Well, first of all, as I mentioned, Lex Sportiva is the internal rules and regulations of sport. It is the statutes and the governing charters of international sports organisations like FIFA or like the International Olympic Committee. So we always start with those key documents when we're trying to establish what it is that we mean by Lex Sportiva. Some people who write in this area say it's only the opinions of the Court of Arbitration for Sport. However, it has to be wider than that because the Court of Arbitration for Sport is more of an interpretative body. So when it determines how a rule or a regulation or a charter will apply to a particular issue, that then goes back to the international sports organisation that sent it in the first place. So Lex Sportiva has to be wider than the opinions of the Court of Arbitration to include all of those key foundational documents that govern sport. Sports law, on the other hand, is the case law, the statutes and the international treaties that apply to sport. So it can be cases such as Bosman, who we've already mentioned, starting off his challenge to the transfer system as it used to operate in Belgium and throughout Europe by simply bringing a case before the high courts in Belgium. That's how his case started. He simply decided that it was unfair for a rule of the Belgian FA to stop him from being able to move from one employer to the next. And if you think about it in terms outside of sport, when you come to the end of your contract, you are unemployed. You are no longer employed by your previous employer. They are no longer expected to pay you. And in any other environment apart from football, you would be able to simply join a new employer. But at the time, even if your contract had finished, as it had with Bosman, he could not move to a new employer without permission from his previous employer and without them being paid a transfer fee. And that was considered eventually by the European Court of Justice to be an illegal infringement of his freedom of movement. So we see from situations like that that normal law applies to cases. We can also have specific statutes that apply to situations. And in the UK, we have the Olympic Symbols Protection Act, which stops anybody other than the British Olympic Association from using the Olympic rings in the UK. The reason why something like that is so important is because the only other international organisation that gets similar legal protections in UK law is the Red Cross and the Red Crescent. So they are protected by law, and the only other international organisation with similar protections is the IOC and its rings. So we can have specific statutes. We can also have international treaties. And sticking with the Olympic symbols, the World Intellectual Property Organization's Nairobi Treaty on the Protection of the Olympic Symbol is signed up to by around 70 nations around the world to provide that sort of protection to the Olympic symbol. We then see Lex Olympica, and a little bit more detail here that, like Lex Sportiva, it starts with a governing charter this time, the Olympic Charter, but it also includes all those documents that flow from it, like the Athletes' Declaration, the Olympic Host Contract, and decisions of the Court of Arbitration for Sport about the interpretation of the Olympic Charter. And then we have Olympic law. And we can see that through the statutes that are required of each Olympic host of the Summer and Winter Games that have been forced on host jurisdictions since the 2000 Games in Sydney, Australia. And since then, what we've seen is a constant evolution of the requirements that the IOC imposes on the hosts of each edition of the Games. But how that also then starts to spill into other events. So in the two Commonwealth Games that have been held in the UK since the London Olympics in 2012, Glasgow in 2014 and Birmingham in 2020, at both of those events we had almost identical legislation in place to show the importance of Olympic law and its influence on other events. So that gives us a kind of idea about what these various terms mean. And what you should be able to notice quite quickly is that we really have two sporting legal systems here. And we have to remember that sport is governed by both at the same time, and that's why it's so important to get this terminology right. We have these parallel systems of governance in place. The first, and the one that is most commonly used, is the internal system that uses the structures and processes of a sport and often ends up with a decision from the Court of Arbitration for Sport. So that's our Lex Sportiva and our Lex Olympica. But then we also have the external imposition of the law by governments, by courts around the world, and that is our sports law and our Olympic law. So we have to bear in mind we have these two systems in place. So this is what the very basics of the Lex Sportiva and Lex Olympica systems will look like. These cases usually either come from the World Anti-Doping Agency, from an international sports federation, or from the International Olympic Committee. Once the decision of those has come to their highest internal tribunals, there will usually be an appeal that can go to the Court of Arbitration for Sport. So as you can see, what we've got is a wholly internal legal system that sits, to a certain extent, outside of the way that sports law usually would operate, or law would usually operate. So we'll touch on this case we've already mentioned it, and we touch on it again. The case of Claudia Pechstein, the German Olympic ice skater, who was found guilty of an irregularity by the World Anti-Doping Agency and was effectively banned from competing in the Olympic Games for 4 years. Her initial challenge was against the decision of the World Anti-Doping Authority and went up to the Court of Arbitration for Sport, where she was forced to have her hearing. She was not supposed to use the national courts, although eventually she did, but she had to go to the Court of Arbitration for Sport in the first instance. We mentioned Dutee Chand and her challenging to the entry regulations on how to classify female athletes in world athletics, and her final appeal to the Court of Arbitration was rejected. And then we have challenges to the IOC and to the Olympic Charter itself, and in a case that involved the United States Olympic Committee challenging the International Olympic Committee, where the IOC had sought to introduce changes in the Olympic Charter, which would mean that anybody who had been banned for a doping offence that resulted in a ban of 6 months or greater would be banned for an additional Olympic cycle at the end of their banning period. So for an additional 4 years on top of whatever the World Anti-Doping Agency thought was appropriate. This decision was ultimately found to be ultra vires, because the IOC did not have the power to change its own constitution in respect of doping matters. It could only ever apply them in accordance with the World Anti-Doping Code. And that code set out what the punishments should be. So in each of these cases, we get a final determination on the issue from the Court of Arbitration for Sport. Or at least that's what many people will tell you. But don't forget, right at the start, I said that this autonomy of sport to regulate itself is conditional. And here what we mean is that there is a limited right of appeal from the Court of Arbitration for Sport to the Swiss Supreme Court, which is called the Swiss Federal Tribunal. And as we've seen in more cases recently, ultimately from the Swiss Federal Tribunal, you can appeal further to the European Court of Human Rights in some limited situations. So when Pechstein had exhausted her appeal before the Court of Arbitration for Sport, she appealed to the Swiss Federal Tribunal, where again she lost. It was held that the rules in respect of doping appeals were fair, reasonable, and proportionate. So she ultimately appealed to the European Court of Human Rights, which determined that, in a partial victory for Pechstein, that these hearings must be held in open session. In other words, because of the importance of the hearings of the Court of Arbitration for Sport, you must treat them like proper legal proceedings with proper rules of evidence and the right to a fair trial. And we've seen that repeated with the Caster Semenya decision, where she challenged the rules of world athletics. That was appealed up to the Court of Arbitration for Sport, where she lost. She then appealed to the Swiss Federal Tribunal, where again she lost, where the Swiss Federal Tribunal held that the rules that prevented her from competing were reasonable to protect the integrity of women's sports. Yet when she appealed up to the European Court again, she has partially at least won, because the European Court of Human Rights stated that there had been no proper human rights analysis of her challenge. So what they've done is insisted that her case is reheard before the Court of Arbitration for Sport and listens properly to her human rights claims around discrimination and privacy. Regardless of the ultimate outcome of the Semenya decision, and World Athletics is likely to appeal it to the Grand Chamber of the European Court of Human Rights, this decision is seminal as far as sports law is concerned, because the key finding of the European Court of Human Rights in this case is that the European Convention on Human Rights now applies directly to all Court of Arbitration for Sports hearings. In other words, the Court of Arbitration for Sport must now take into account all articles of the European Convention on Human Rights. What's also important is because of its interpretative role in the rules and regulations of other sports organisations, that means that the European Convention now applies indirectly to all governing bodies who are based in Switzerland and to all governing bodies and international federations that have their final route of appeal to the Court of Arbitration for Sport. So the Semenya case is likely to be absolutely pivotal as we go forward, as it will require human rights considerations in any cases that raise them. Now, if we turn to sports law, what we see is a very simple structure of normal legal provisions. So what we look for then is an act of Parliament or an issue from the common law that has been breached simply by playing sport. That case will usually be heard in a regional or high court. There will be at least one route of appeal, and usually up to the Supreme Court of the country in which the case is taking place. If the nation is a member of the European Union or of any other transnational organisation, there may be a final appeal up to the court of that transnational organisation, such as the European Court of Justice. And these things can be quite basic. As I've already mentioned, we need a change in the law of consent to enable fighting sports like boxing to take place. if we don't allow people to punch each other, if we don't allow consent to be varied to enable fighting sports, then all of those fighting sports become illegal. So it demonstrates again this idea of specificity. Without a slight tweak to the law on consent, we have no combat sports, and contact sports themselves become difficult. We've already mentioned Bosman, which is one of the cases that went right the way through to the European Court of Justice, touching on each of these court structures to enable a determination on freedom of movement. And we've seen something similar this time coming out of the Spanish High Court with the European Super League case, with a claim from the Super League company that the rules of UEFA and FIFA are anti-competitive, that they are an abuse of a dominant monopoly position by UEFA that is stopping them from developing their own alternative competition to run alongside UEFA's. Now, ultimately, the courts have found that the procedure that is in place and run by both UEFA and FIFA to enable a new competition to be authorised is clear, it's transparent, and it's reasonable and proportionate. Which means that Super League cannot really apply to become an official competition, but that doesn't mean it can't just simply set up. And as we've seen in golf recently with the Saudi Arabian funded Live Golf tournament, if an organisation simply has enough money, there is always the potential for it to set up an alternative structure. There have been threats in tennis, threats in swimming, and I'm sure we'll see others when new bodies want to challenge these kind of developments. And finally, in all of this, I just wanted to touch briefly on Olympic law, because this is a very peculiar type of law. And what we see is this sort of circular process that occurs. So what we found before the Sydney Games in 2000, the IOC had decided that in particular what it wanted was a regulation of what it termed ambush marketing. That is where non-sponsors try and capture the market by attracting attention to their own brand instead of paying to be associated with the Olympic Games itself. So that was the initial thing that they wanted to do. They wanted to regulate advertising in the stadium and in the immediate environment of the Olympic venues. So what they then do is include those requirements in the Olympic host contract and say you must introduce regulations at city level or at state or national level that regulate ambush marketing. So that requires the hosts to pass laws that will protect the IOC and its sponsors, and it requires those to be produced in national law. And at every game since Sydney in 2000, there's been increasingly stringent requirements imposed on the host countries. At the end of the games, the host reports back about the effectiveness of the Olympic laws and whether or not it needs changing. Usually they all say it needs to be made more restrictive and the punishments need to be greater. So the IOC then updates its own internal rules, its Lex Olympica, and then the whole process starts again as it requires that new system to be in place for the next Olympic Games. So what that means is then we end up with a new form of law in the host, which can then be used as a template for the next Olympic host, and as we saw for the Commonwealth Games, is often used as a template for other events that take place in the same or other host countries. So that gives us an idea of what sports law is and where it comes from and how it operates and interlinks with the governing rules of sport and with the law in each individual country. But as I mentioned, some people still refer to this as sport and the law, and that's because of the huge range of legal fields where sport and the law interact. I'm not going to go through all of them. You're going to go through a wide range of them this week. But I am just going to briefly touch on a few to show how and why the law is applied differently, and why we need to remember that sport is special, that sport is different, that we need to take into account the specificity of sport, but also that we need to ensure that we remember that that autonomy of sport is conditional. So I've touched on the issues of the legality of boxing, and that was first heard before the House of Lords, as it then was, back in the 1860s. And this followed nearly 150 years worth of cases that had been heard by the British courts about the legality of fighting sports, about prize fighting, and about football and rugby. And this is what I actually did my PhD on when I started back in the mid 1990s. It was looking at the law of consent and how it had evolved over the previous 300 years to enable us to become in the position that we are now, where combat and contact sports are legal. So that brings in issues of criminal law, it brings in issues of the law of tort, about where we're trying to ask for compensation for injuries. But obviously what it also demonstrates is that we need exceptions for sport to enable these sports to continue. And the justifications for things like consent being adapted to allow combat sports is that sport is good for you. It's good for your health. It teaches you about teamwork. It teaches you about health and fitness. It enables you to make friends with a wide group of people, and it enables you to demonstrate skills that you can't in any other area. It also enables you to learn things like teamwork and fair play. So the British courts have been quite clear in the ways that they feel that sport is a good thing that needs to be protected. I've mentioned Bosman a couple of times, but this was, as I talked about just a few moments ago, it was really just a classic employment law case or a classic freedom of movement case. Bosman's former employer was trying to claim that they were owed a transfer fee after the end of their contract. Now, for most of us, if we want to move jobs, we simply hand in our notice, we resign, and then we can go to another job. Hopefully a better job, hopefully a better paid job. And that's all Bosman wanted to do. His old club no longer thought he was good enough to play for them. He was offered a job by a French club and he wanted to move there. And the law as it applied in Belgium at the time said, no, you can't go. Now, if you'd asked an employment lawyer if that was legal, they'd have told you, of course it isn't. If you'd asked an EU lawyer whether that was a breach of free movement, they'd have said, of course it is. But the transfer system had become so entrenched in football that nobody else wanted to accept that the law applied, which of course it did. So we have seen significant changes in the transfer system. And there are further challenges to the transfer system coming out of several Belgian cases at the moment, where they think that even in-contract transfers should be illegal, that if you want to leave your current employer, you should simply be allowed to resign. So we'll have to wait and see what the Court of Justice says about that. In Gundel and the International Equestrian Federation, we saw the first time that a case went from the Court of Arbitration for Sport to the Swiss Federal Tribunal. And Gundel's claim was that as the Court of Arbitration used to be, it was funded almost exclusively by the IOC, and the IOC created the governance structure for it. The Swiss Federal Tribunal held in Gundel that there was no problem of a lack of independence or bias in a case involving the International Equestrian Federation. But they made the very clear point that if the defendant in this case had been the IOC, then it would have been found to have been an illegal arbitration process because of the lack of independence. So that meant that in the mid-1980s, what we see is a complete change in the way that Court of Arbitration for Sport is organised, is run, is funded, so that it looks more like a genuine independent process than it did previously. I've mentioned Pechstein on a number of cases now, that the Court of Arbitration for Sport must apply rules of due process or a fair hearing or procedural fair play where cases are heard before it. And this was an acknowledgement by the European Court of Human Rights that the European Convention had to apply to these arbitral cases because they are so important to an athlete's lives. There was no problem, they felt, with requiring athletes to have their case heard before the Court of Arbitration for Sport, because that will usually be a very quick process that will take somewhere in the region of 6 to 9 months. Whereas if it goes through the normal court processes like Bosman did, it can take 6 years or more, which was the case for Bosman. So we know that athletes' careers are short. We need to make sure that they're using these sports tribunals. But by forcing them to use these sports tribunals, we have to make sure that those are operating fairly. Very recently, we've seen a massive change in the way that sport is organised in the United States of America from the NCAA case against Alston, which effectively said that we need to stop pretending that college sports in America are amateur. They're not. These athletes are paid very substantial amounts of money and ought to be paid properly for the use of their name, image, and likeness rights. So in other words, we're extending intellectual property law to individual athletes throughout the college sports system. And that's had a seismic change. It means that some of these athletes now are able properly to exploit their name, image, and likeness to be able to produce millions of dollars for themselves that now goes to them and not to the NCAA or to their host institution. I mentioned the European Super League on a number of occasions, which has effectively said that yes, it's okay for a governing body or an international federation or a continental association to be a monopoly. However, what it does need to have are open and transparent rules that enable people to develop alternative competition structures. We can have national laws that protect the Olympic symbols, and many countries around the world have that in place, whether or not they have hosted the Olympics. Most that have hosted the Olympics then keep them in place. But also we have transnational treaties in place, like the Integrated Safety, Security and Service Approach of Sports Events, which is a treaty that establishes what best practice should be for the running and organisation of major sporting events throughout the wider notions of Europe. So that's from the Council of Europe. So although it's often not binding in each of the countries and further legislation is required, what we do find is that almost all the signatories of that treaty have changed the way that they operate to ensure that a variety of separate laws have been introduced into their own legal systems to ensure that they are safe and run properly. As one signatory, though, France is finding out, just because you're a signatory doesn't mean that that makes you safe. The issues at the Champions League final last year and a couple of weeks ago in Marseille at the Rugby World Cup have demonstrated that we need these treaties operationalising, not just existing. We need that law to be imposed. So they're the kind of issues that have come up about sports law over the last 30 years or so in particular, since I've been looking at this area. But we can also see these laws tracing back their longevity to sometimes several hundred years ago when we're talking about crime and tort, and a number of them to the late 1800s, as we start to see governance structures and governing bodies starting to run sports around the world. And now what we find is countries around the world learning from these issues of best practice in states that have accepted sports law and trying to ensure that they themselves are able to govern and regulate their sports appropriately. And as you'll see throughout this week, we've touched on a number of issues today, and you will touch on a number of them further this week that will bring in contract, tort, crime, administrative law, human rights, all sorts of issues. So to be a sports lawyer means that you do have to be either a dedicated specialist of one particular issue and make sure that you are a brilliant contract lawyer so that you can deal with players' contracts. Or you need to be aware of the kind of things that I've talked about today. You need to have that very broad range of knowledge to ensure that you understand how the law is likely to develop, to evolve, to apply to any particular sporting issue. Which brings me on to the last couple of issues I just want to mention in this opening session today. And that's, having looked back at how sport has evolved, maybe we also ought to start looking forward to the future of what sports law is and where it might go next. And these are very much my personal thoughts on these issues. But I think that they are issues that are likely to be ones that, if you go on to be sports lawyers, will dominate some of the issues that you need to be dealing with. And first of all, particularly as a result of the Casta Semenya decision, I think what we're going to see a lot more of now is a recognition that human rights apply to sport, and that sports organisations need to ensure that their activities are human rights compliant. Now, a lot of major organisations do now claim that they respect and protect human rights. The FIFA statutes in Article 3 have stated for a number of years now that they will respect and protect, also that they will respect and comply with all major human rights instruments. Now, that is a huge and very difficult claim to try and substantiate. To say that you will be respectful of all human rights in all treaties around the world is really making it very difficult for you to ever achieve that. But it's there. And that's what they must do. The IOC, at its upcoming executive committee board meeting, is stating that it too will change the Olympic Charter to reinforce its commitment to respecting and protecting human rights. But how will this play out? Well, first of all, it's one thing for an organisation to claim that it respects human rights and that it's going to protect them, but there's not a single governing body of sport yet that actually has a remedy structure in place. So where someone's human rights are breached by sport, whether it's an athlete or a team or the workers who have built the stadiums, there is no remedy mechanism that they can utilise to ensure that they are able either to receive redress or compensation for those human rights breaches, or that they can get the behaviour of the sports body changed. So that's something I think we'll see a lot of. But also, sport might be very defensive. It might decide that it needs to relocate the Court of Arbitration for Sport outside of Switzerland and potentially outside of Europe so that the convention no longer applies. And we might also see other international sports federations relocate outside of Europe or insist that their appeals to CAS are held outside of Switzerland. So we need to be able to take into account these very important developments. And sport has often been very bad at this. In the past, what we've seen is people telling major sports bodies, you do know that your laws are illegal. Football was told for many years that a Bosman-type case would succeed, that EU law applied to it, and it chose to ignore it. What we then obviously saw was EU law applying. And it's been the same with human rights. And what we will now need is for sport to be more proactive to ensure that human rights are protected. We're also, I think, going to see a lot more about unauthorised competitions or breakaways. And cricket has always been very good at dealing with potentially problematic competitions. In the 1970s, the Australian media magnate Kerry Packer established World Series cricket, where he bought the contracts of a number of the world's leading players and then sent them out on tour around the world to make sure that he was able to broadcast those very best players in his own competition. After a number of court cases in the UK, there was an agreement eventually between World Series Cricket and the International Cricket Council, which ensured that we ended up with a new way of governing sport, and with Packer helping to develop one-day cricket. And with the one-day cricket World Cup taking place in India at the moment, that would not actually have occurred or not occurred in the same way if it hadn't been for these challenges in the 1970s, which established, first of all, a rival competition, and then secondly, incorporating that rival back into the mainstream of cricket. And we're seeing something potentially similar in golf. At first, Live Golf paid huge sums to a number of golfers to come and play in this unauthorized breakaway competition. But now what we're seeing are moves towards Live merging with the PGA to ensure that we have one combined tour in America and in Europe. So these breakaway competitions, I think, will continue to cause trouble for established governing organisations, and they need to be aware that they cannot abuse their monopoly positions, that they must ensure that they have reasonable and proportionate restrictions in place, and that their rules can withstand legal challenge. Alternatively, they need to be able to negotiate with potential rivals to ensure that what they're doing is legal and can be brought in. Sport also needs to deal with these issues of discrimination. We've seen a number of impacts from the Duty Chand case, from the Caster Semenya case, and the way that DSD, or the differences in sexual development, is governed by sports around the world. And we've still yet to see the ultimate outcome of the Semenya decision. But on top of that, we need to deal with issues relating to trans athletes as well, and especially as there's no formal or recognised definition of a trans athlete across sports or in law around the world. So sport needs to be aware. It can't just say no, but it needs to be able to explain how and why it comes to the restrictive positions that it does around athletes with certain characteristics. We're also likely to see issues relating to equal pay and equal treatment coming. And in a number of the major footballing jurisdictions around the world, we're starting to see movements towards, first of all, equal treatment to ensure that female footballers are able to play on the same pitches, that they're able to receive the same medical advice and treatment as their male counterparts. But also we're starting to see moves towards equal pay as well. And if you think about a single employer, a football association, how can it justify being the centre forward for England, and if you're a man you get paid more than if you're the centre forward for the women's team? What we've got there is a description of a job. You will be paid as a professional footballer in this team. Why are we allowing for differences of payment? There may be justifications, there may not, but what sport has never done is deal with these issues head on. So something it will need to do is ensure that all these discrimination issues are treated appropriately, and preferably before they get to court. Because one thing you might have noticed in everything I've talked about this afternoon is that when sport goes to court, it usually loses. And so it needs to be aware that in each of these areas it's likely to again. Finally, the issue of ambush marketing, which is evolving massively. The laws that the IOC requires at the Olympics really don't deal with ambush marketing properly. They stop posters being around the Olympic venues, but what they don't deal with is online and social media marketing. And it's that we'll see, I think, as the next stage. And we'll need a trade-off between what athletes are allowed to do and what organisers of these mega sports events want us to do. So they're just some ideas from the work that I'm most intimately involved with at the moment as to where sports law may go next. But I think what we can all see is that sports law is not going away. It might have taken a few years for everybody to accept that it's here, but in the time that I've been involved with sports law, and it's been an incredibly enjoyable 30 years that I've been involved with sports law, what I have seen is a total change in the way that these issues are dealt with. And it's one of the reasons why I think that this particular certificate that you're all involved with is so important, because what you're doing is ensuring that you are able to shape India's response to these issues, some of which have occurred elsewhere, others of which haven't, some of which you can learn from and maybe incorporate or use as best practice, but others you might think are terrible ideas and you're able to come up with a different alternative. So all of these issues are bubbling there in the background, but in many ways, although I feel myself to have been incredibly lucky in being at the start of a number of these issues, I think you're also incredibly lucky coming into a situation where you're able to draw on the advice, the help, the wisdom of other people to help you develop your career in whichever direction you'd like it to go. On this final slide, if you, when these are circulated, you can click on each of the links and each of those images, and it can take you through to those particular outputs and publications. I'd particularly point you towards the International Sports Law Journal, which is the leading international journal for sports law issues. And we are increasingly getting contributions from Indian authors, which has been fascinating to see as people engage with sports law on a much more regular basis in India. But that's where I'll leave it for today. And thank you very much for inviting me. Thank you even more so for listening. And if anybody has any questions, I'm more than happy to take them.
Well, James, hi. I couldn't join earlier, but because of some work. But it's great. Thank you for accepting the invite. I just wrote to you once. If you can't recognize me because I've shaved, this is Tarun this side, because you've generally seen me with a full beard.
Yes.
But it's absolutely great to have you, to see you. And thank you for coming for this course. I'm going to teach tomorrow. So it's a huge honor to just be on the same poster, on the same brochure where your name has come in. I'll very soon see you in Netherlands for the conference as well.
Yes, and thank you again for the invitation, Tarun. It's been a pleasure being here today.
I think there is one hand raised, Professor. I think we can take that question. Okay, why is the name of the person? If you can unmute yourself and ask the question, I think that will be easy for Professor James. There is one on the chat, which... Yeah.
Can I go ahead?
Go ahead.
Mark, can I go ahead, please?
Yes, of course.
Yes.
See, all of us are in India, and sports is a big event here. In villages, urban areas, we keep playing sports and we indulge in various kinds of activities. There is one particular aspect which is particularly legalized, say in England and many places in Europe, but India looks at this aspect very, very differently. That is about, say, betting, kind of gambling, or anything which is regarding the sports where people want to participate and some companies want to make money. So what is your take on this and how the Indian system should proceed further? Thank you, sir.
That's a huge question. You could probably have an entire week's worth of sessions on gambling and how to regulate it. In the UK, we've gone about it in a very specific way. Gambling has always been accepted, particularly within sport, and we have a huge number of our major professional teams are actually sponsored by gambling organisations, which is something that not everybody is in favour of. What we are more concerned about is not so much gambling, because we've always had it. And indeed, for some sports, like boxing and like cricket even, the rules became standardised to enable gambling. They were vehicles for gambling. So in the UK in particular, we're used to sports gambling. And we don't think of it as being necessarily a bad thing most of the time. So instead, what we have are the criminal issues that go around match fixing. So you are likely to be investigated and prosecuted if you engage in any sort of interference with a game. Now, that doesn't have to be just that you're fixing the outcome of the game. It can be what's called spot betting, where you are trying to, say, for example, in cricket, that you will bowl a wide in the third ball of the sixth over. And then people bet on that, and you receive money from them. All of that is illegal under UK law, and in many other jurisdictions it would count as fraud. I think where it's more difficult, and probably a good way of seeing how a totally different jurisdiction has evolved its laws in this area, is in the United States of America, where sports gambling was illegal for many, many years, and only recently have they started to allow it. And they're finding it quite difficult to understand the volume of gambling and the variety of gambling that occurs worldwide. I guess the problem we have is more around how do you regulate often the more unofficial or illegal gambling that takes place worldwide, where you've got state licensed gambling organizations like we have in the UK. It's very easy to regulate gambling, but what we can't do obviously is regulate illegal or underground gambling that might be taking place in India, in China, in other countries. So that's where the difficulty comes about. And I know that that's why many sports now are starting to have integrity officers to try and deal with match fixing alongside of doping. So I think that's a very long way of saying that it's probably something that the sports themselves need to deal with in conjunction with national authorities to ensure that sports integrity is protected.
And there's another hand raised, Professor Anurag. If you can unmute yourself, Anurag, and tell us your question. Anurag, if you can unmute, I'll unmute you. Yeah, now you can ask the question.
Hello.
Yeah.
Am I audible?
Absolutely.
Hi, Mark. First of all, thanks for this amazing session. Really learned a lot. Appreciate all your time and efforts. So my question to you is, so in the Premier League, when Saudi takeover was completed for Newcastle United, there was a lot of governmental regulations, and which I also frankly expected if the Qatar's bid for Manchester United go through as well. So can you shed some lights on the intricacies and the legalities which are there in the UK when certain states or state ownership of clubs that do happen?
I think the way that it was reported probably made it seem like there was more regulation than there actually is. One of the reasons why state authorities like Saudi or others, the Emirates, as far as some of the other sports are concerned, the ownership of Manchester City as well, and also by various oligarchs like Roman Abramovich for many years. We really don't have much restriction in who can own a football club, and that's part of the problem. So although there was some disquiet about the takeover of Newcastle by the Saudi Investment Fund, there was very little that either football or the government could do to stop it from happening. And it would be the same if Qatar either take over or buy into Manchester United, there's very little that can be done in English law to stop it, and there's very little in the Premier League rulebook to stop it from happening. So we probably are about 25 years late in dealing with this. When Roman Abramovich took over Chelsea, that's when we should have dealt with it, and that's when we could have said, right, these are the rules for taking over a football club. Instead, what we have is what's referred to as the fit and proper persons test. And that really just means, have you ever been convicted of some sort of corporate offence? If you've not been convicted of a corporate offence, we generally don't look at where your money's come from. So there's actually very little we can do to stop the takeover of our football clubs. Now, as a result of that, the government has said it will look into whether or not we need an independent regulator for football. And also, because of the racism claims that have been made in cricket, there's talk of an independent regulator for cricket. Whether or not those ever happen, your guess is probably as good as mine. But what they would then hopefully do is try and help to define what the rules should be in these situations, and who actually is an appropriate person or an appropriate body to take over our leading clubs. So, much as I'd like to be able to say that there were all sorts of legal intricacies, actually there was very, very little that anybody could do to stop this takeover of Newcastle United.
Right. I think there are a number of questions coming in. Let's take at least a couple of them, if Professor, you have the time.
Yes, of course.
Yeah. George, please go ahead. I think you had raised your hand first.
Firstly, thank you so much for giving me this opportunity to ask this question. My question basically to Professor Mark is, now we've heard of financial fair play being a major factor in football in the coming years, or it has been now. Now, the biggest question is, now with Europe not having a comprehensive legislation on the financial fair play and different leagues having different financial fair play situations, can there be a possibility where we can have one financial fair play regulation in the coming years, which could possibly govern a lot of these leagues? Because now we've seen with La Liga, one of the biggest issue has been the financial fair play regulations, and clubs like Barcelona trying to fight it out. And there are questions of discrepancies even in that league. And with Premier League, you're seeing influx of money flowing in as well. So where are we heading to with the financial fair play regulations in European football?
I think that's a really interesting question, George, and I think it's one that's almost impossible to answer. I think the difficulty we've had is that when UEFA introduced these regulations, it was for good reason. What they were trying to make sure is that originally clubs didn't spend all their money on wages and then run the risk of the billionaire owner leaving and the club going bankrupt. And we had a number of cases where that happened for clubs that have been around for well over 100 years and were simply badly run. Portsmouth was one of the key examples a few years back. The problem with UEFA's financial fair play rules is that they've never really been fully enforced. So you're left with a peculiar situation where clubs like, in particular, Real Madrid spend hundreds of millions of pounds every year. Chelsea spent over £1 billion this last summer. Other clubs undergoing similar kind of spending, yet none of them are ever apparently in breach of the financial fair play rules. Manchester City have been in trouble on a number of occasions with the authorities, but they still can't actually find the evidence to prove they've done anything wrong. The financial fair play rules are relatively straightforward and relatively simple, so you'd have thought it would have been clear when a club was breaking them. But our problem seems to be a reluctance by UEFA to take on some of these clubs or their owners. And so we're left with a situation where we don't really know what those rules are. What that then leads to is independent countries introducing their own versions of financial fair play, which we have in the Premier League in England, and as you mentioned, in La Liga in Spain. So we're left at a really difficult situation here. The other problem is trying to get something that applies across an entire continent, or potentially through FIFA across an entire global sport, that it's very difficult to regulate because the rules are very different and the laws are very different in each country. So what might look like it's a great idea to work in the UK might be illegal in Germany. What looks like it might work in the EU might not work in Eastern Europe, where a number of members aren't, or in the UK, where we're not members of the EU. Or it might not, it might work through the Council of Europe, but it might not work outside of Europe. So we've clearly got a problem here that needs addressing, but I think that the failure to address it early, particularly in the Premier League, and the failure to address it on a continental basis by actually enforcing the financial fair play regulations as developed by UEFA, means we're probably never really going to get to the bottom of this. And I think the regulations are likely to be less strictly enforced as the European leagues start to be more concerned about the purchasing power of Saudi Arabian clubs at the moment, because they don't want the players to go there. So they would, I think, will find a relaxation in financial fair play to try and stop Saudi Arabia buying up all the best players.
Just one supplementary question on this, Professor. You just mentioned that UEFA generally takes a back seat in terms of calling out these clubs which don't adhere to the financial fair play regulation. This is majorly regarding the economic grasp they have over the system, or there are other factors as well?
I wish I had the answer to that one, because then I would either be incredibly rich or a pariah as far as UEFA are concerned. I think it's a combination of the two. I think there's a lot of political issues going on in the background to protect a number of the big clubs. To ensure that they don't go bankrupt as a result of having the financial fair play rules imposed on them. But also, as soon as the rules are developed, the clubs come up with new and unusual ways to try and evade those rules. And we've seen that with Chelsea offering, instead of 5-year contracts, are now offering 8 and 10-year contracts to young players. So it looks like they're not in breach. So yeah, it's a combination of things. There's no one issue really that you could highlight.
All right. Prithviraj, I think you've raised your hand. I think we can have one. Yeah.
Good afternoon, Professor. Thank you for such an enlightening session. Really enjoyed it. I wanted to ask whether you can name the top universities to pursue sports law in, masters in sports law in, across the UK and Europe. Also, I wanted to ask you whether what's the requirement to practice sports law bilaterally in the UK as well as India?
That's a much easier question to answer, because there's no specific difference as far as sports law is concerned. So if you have qualified as a lawyer in India, you would simply have to undergo the qualified lawyer's transfer test in the UK, and then you'll be able to qualify as a solicitor in the UK and then practice whatever area of law that you wanted to. So sports law would obviously fall within that. As far as master's courses, the UK market has very few that are aimed at really developing a career. They're very much introductory and very similar to the kind of things that you'll be doing this week on the certificate. Though, depending on what area you were looking at, if you wanted to do more of a research master's, then I think the team we have here at Manchester and also the team over at Edge Hill with Richard Parrish are probably the strongest UK groups of sports lawyers. The ISDE in Madrid does a very, very high quality master's, but it's also very expensive. That could be worth looking at. There's also a number of fantastic master's programs throughout North America, particularly where the sport and entertainment programs. There's a number of those that are worth looking into. The University of South Carolina in particular has an excellent one with John Grady. There's been work on it up at Marquette in Milwaukee. And at Harvard, obviously, they run programs as well. So there's a huge range that would enable you to pick the kind of specialisms that you're most interested in. So North America is the most developed market. More of research rather than a broad masters in the UK.
Okay, thank you so much, sir.
Pleasure.
Professor, I have another question. If you can throw some light on that. Look, I think I'm very sure a lot of people look at India as one of the major growing market in terms of sports. But unfortunately, because I am in the industry, I've been teaching for a bit. This whole aspect of sports law and its future is a little questionable. If to use this word, is a little questionable when it comes to India. What do you think for a country like India, which is growing in the area of sports? What kind of things should we develop? If you can just maybe pick 3 or 4 policy inputs that you can give us that we should keep in mind while developing sports law in this country. Where is this lag happening actually, if you follow the Indian market and how we've been developing?
Rather than 3 areas, I think there's just one, and that's to make sure that the governance is correct. Almost all of the cases that have evolved over the years have occurred because of a failure of governance by the sporting authorities in a particular country, whether it's failure to protect intellectual property, whether it's not having rules in place to stop people from fighting to the death in boxing. It doesn't really matter how you look at it, right the way through up to freedom of movement and doping and match fixing type of issues. It's all about governance when it comes down to it. So I think with a country like India getting into sports law, the first thing you need to do is make sure that your key governing bodies, including the Indian Olympic Committee, they have to make sure that their governance structures are absolutely correct, because if the rules aren't right in the first place, that's where most of the litigation will begin.
And there's one interesting question on the chat which says that how do you perceive sports law as an independent branch versus sports law as an amalgamation of different fields of law? Where do your understanding goes? What do you understand by it? And where will you put sports law, whether it's a amalgamation of all the laws or is it an independent branch? And if yes, then what's the difference?
I think my personal feeling on this is that having started as more of an amalgamation of laws that simply dipped into contract or crime or administrative law, it is now genuinely a separate area of law. To a certain extent, it doesn't matter whether you call it sports law or sport and the law, and a lot of people will use sports law simply as a short an easily understandable term. But for the reasons that I was talking about earlier, I think that sport is different. Sport needs to have these exceptions and needs to have the law apply to it in a different way. And we need to constantly be thinking about that as we approach the different cases. Are we just going to apply contract law, employment law, criminal law to a sports case? Or is there something special about sport, or this particular sport, or this particular aspect of sport? And if there is, we've started to see over the years, and in particular through EU law, and in particular the introduction of Article 165 into the European treaties about needing to recognise the specificity of sport. It gives us that understanding that most of us don't need dope testing. It doesn't affect the way that we would run our job. And actually, some of our employers might want us to do it better and be more awake or more alert. But we need to be able, if we are going to say that sport is about drug-free sport, then we need obviously to be able to invade people's privacy. We need to be able to take blood and urine samples. We need to be able to knock at their door at 6 o'clock in the morning and make sure that they are clean. So I think, although it looks like it's a lot of very disparate ways, if you ask yourself each time, is the law acting differently because this is a sports case, you'll often find that yes, it is. And I think that's where sports law comes into all this, that it is the understanding that sport is treated differently by the law in a huge range of situations. And tied into that, one of the other questions that's come in on the chat about can one choose lex sportiva, actually generally no, because it's forced on you. That's what you usually find. So the Claudia Pechstein case was specifically about that. She said that it was a requirement of her competing at the Olympics that she could only challenge her case before the Court of Arbitration for Sport. She said she wanted to take it to the German courts where she was convinced she would win, and this idea of forced arbitration would be declared illegal. So often, once you, particularly if you're an elite athlete, you have to use lex sportiva in the first instance. You will have to challenge within your own sport's governance structure, and then to wherever it allows you to appeal ultimately, like the Court of Arbitration for Sport. And any Olympic sport will require you to do that. And in a lot of these cases as well, Swiss law will be the governing law. So we've had cases involving football transfers of a Brazilian player trying to move from a Ukrainian club to a Spanish club. You would have expected that as he was employed by a Ukrainian club, it would be Ukrainian law, Ukrainian employment law that would apply. But all international transfers are governed by Swiss law because FIFA is based in Switzerland. So although there was no other link with Switzerland apart from the requirement of FIFA that it was, then that's how we end up being subjected to lex sportiva. So particularly with the elite athletes, it will be imposed upon you rather than you choosing it. If it's not imposed upon you, then most would either submit to lex sportiva because it's quicker, or if they feel that they need the law actually changing like Bosman did, that's when you'll go to the courts.
I think we have one more, Professor, and then we'll call it a day. Shreyas, I think you've raised your hand. Please go ahead.
Good afternoon, sir.
Good afternoon.
Actually, I had to add on the amalgamation of sports and law part. So I feel, sir, in India, it is the regulations out here are there present and they are rigid and strict. But in terms of the administration exercising such regulations, are not exercising that discretion in a better way possible. Because the recent example of the track and field events which took place in Delhi, the state or the national events, so there were photos and images coming out of that events that there were certain numerous number of athletes taking it performance enhancement drugs and everything. So I feel, sir, the regulations are present in India, but then the administration and the bodies regulating such regulations and restrictions are maybe failing to do so.
I'd have to agree with you on that. I think it is really a case of trying to make sure that, first of all, your rules and regulations are correct and appropriate, and then you need to make sure that they are applied to their fullest to ensure that there is compliance where necessary, that there is the ability to restrict and punish those who are in breach of it. So again, it comes back to what I was saying about earlier. Probably the most important issue as far as an emerging market like yours is to get the governance structures right. And once those governance structures are right, start to actually apply the law and the regulations that you have subscribed to. Because without that, that's where the problems will always arise.
Right.
Perfect.
Thank you.
I think that will be all. If there are other questions, you can either send it to Subramaniam, he can send it to Professor James, or you can even send it to me because I'll be meeting him by the end of this month. So I can ask a few questions on everyone's behalf. But Professor, thank you very much. I just wrote to you once and you accepted the invite here. It's a huge honor. Subramaniam, over to you.
It's been a pleasure, and thank you very much for having me today.
Thank you so much, Professor Mark James and Mr. Tarun Singh. If it was not him, we would not have gotten the contact of Professor Mark James. So special thanks to you for also co-hosting the session along with Professor Mark James. Thank you so much, sir. So I would like to introduce to you guys our next speaker, who is from our very own university, Assistant Professor Mr. Chirag Balyan. He's a professor at MNLU Mumbai with a diverse background in both academia and practical legal experience. With a foundation as a former law clerk, come research assistant at the Supreme Court of India, he brings a unique perspective to his role as an academic and a researcher. Professor Balyan is deeply committed to the field of law with research interests that encompass crucial topics such as overcriminalization in India, problems in the justice system, and humanization of the criminal law. His dedication to advancing legal knowledge is reflected in his various roles, including being the coordinator of the Center for Arbitration and Research, Deputy Director of the Center for Research in Criminal Justice, and faculty in charge of the Athletic Association. So, over to you, sir.
Thank you, Subramaniam, for the kind introduction. I'm going to talk about dispute resolution in sports. Now, today is the first day of your certificate course, and I don't know what are the different backgrounds you come from, whether you have an orientation towards the sports law. Are you an athlete? Are you just a lawyer? So, considering the diverse background I anticipate, I'll be moving from the basics of the sports dispute to how the dispute resolution occurs. Please feel free to ask questions at any point of time. And I would also urge that as far as practicable, keep your cameras turned on so that I know who are the audiences I am particularly addressing in this session. Sports industry. It's a dynamic industry. It's a very big industry, right? We have athletes, we have associations, federations, sponsors, then we also have fantasy leagues. There are so many players and stakeholders involved in this industry. So sports industry, when we talk about it, it's not just about athletes and a game. There are so many private players which are also involved. And therefore, when we talk about sports law, the dispute can arise between a player and a federation, between a player and a club, between player and the international federation, or between private player and a stadium, between clubs and, say for an example, broadcasting organization. So it's a very dynamic industry. It's a very big industry. And to this industry, broadcasting and sponsorship are the largest contributors to revenue. Now, there's an estimate that, just to give you a brief, how big is this industry, that in 2018, 488 billion US dollar was the market value of this industry. And by the last year, it was about to go to 614 billion. There are other estimates that 600 billion mark was already reached in 2014, 2015. So there are different estimates, but the industry is very big. And because there's a great inflow of private player as well as money, so obviously the disputes will arise in this sector. Now, when we talk about Indian sports, right, there is a report by PwC of 2015 which estimated the worth of Indian sports industry to be 144 billion, which is a considerable amount if you just compare it with the 640 billion of the global industry. So India is a major stakeholder, and one of the primary reasons why Indian sport industry is getting commercialized, why it is attracting so much money, why it is attracting so much disputes, because Now, sporting is not just about your national games, Asian games, Commonwealth games, Olympic games, or World Cups. There are so many leagues which have come into the picture, and these leagues could be by the sports federation or they could be in association with the sports federation, like Indian Premier League, then ISL, Pro Kabaddi League, Premier Badminton League, Hockey India League, World Cup. So you think about a sport and there is a league which is commercializing that sport, right? So again, this commercialization, one has to recognize if we have to understand commercialization of the dispute resolution. Now, when we talk about commercial sports dispute could be of many-fold, right? There could be ethical disputes like doping disputes, match fixing, or violation of rules of the game, or there could be commercial disputes. Now, when we talk about arbitration could arise either in the context of CST, commercial sports dispute, or even in the context of ethical disputes like anti-doping. And it is in this respect, sports law is very unique. Because arbitration as a dispute resolution mechanism is only meant for commercial sector, is only meant for the commercial disputes. That too, whenever there is an arbitration agreement between the parties. But in sports industry, even non-commercial disputes or quasi-criminal disputes like anti-doping or just doping, they can also be decided through arbitration. So just imagine a private dispute resolution mechanism resolving quasi-criminal disputes which results into situations akin to punishment and are decided by a private organization, which I will come back to in some time, decided by a private organization in a private manner, not through state courts, not through any international courts, right? So we have commercial sports disputes, right, which arises from the contractual agreements. And when somebody was asking a question whether sports law is a discipline on its own or whether it is just an amalgamation, right? It is important to recognize the kind of disputes which arise, because once we recognize the kind of disputes which arise, doping disputes will not arise under any other industry. They are unique to sports law. So it's not a case that nothing is unique to the sports law. Doping disputes are unique to sports law. Match fixing disputes are unique to sports law. Violation of rules of the game or whatever conduct is there on the field is also something which is only the domain of the sports. So there is something which is primarily sports and sports related disputes, and then those sports related disputes which arise out of commercial transaction. It is only with respect to letter and also the kind of value, the monetary value of those disputes, we overlook traditional sports dispute which arise and which are decided via arbitration or other dispute resolution mechanisms which are contemplated by sporting federations, right? So when we talk about sports law as a discipline, it is important to understand it is important to understand disputes which are unique to the sports industry, as well as the fact that there is a sports industry. See, today is an era of specialization. Dispute resolution cannot be understood by isolating it from the industry we are operating. Every resolution professional also requires industry specific knowledge. For an example, you become an arbitrator in a sports related dispute, but you do not understand the technical nature of the game. Say it is a technical dispute, whether a throw which is made by made by a player is a valid throw or not. Only a technical person can tell. So there is something very specific or unique to this industry, right? Which is the sports industry, and that's why sports law as a field, sports law as a specialization also requires specialization of this industry, knowing the industry, knowing the know-how of this industry, how contracts work, one of the peculiar feature, when I say sports law as a separate discipline, one of the peculiar feature of the sports law which distinguishes it from the other discipline is the bargaining power. Most of the transactions you see worldwide, unequal positions are not recognized. All those contracts will be set aside. But when it comes to sports law, unequal bargaining position of an athlete is not a ground to say that we will not enforce the contract. Right? So again, understanding the bargaining position of the athletes is important in order to understand the true nature of sports law. So today's focus, the first part of the focus of today's session is commercial sports dispute. Now, when I talk about CSD arise out of contractual agreements, and these contractual agreements could be for supplying sports-related merchandise and equipment. It could be about providing services. It could be also about licensing over tangible property such as stadium. So a property law transaction or an intellectual property law transaction, which is intangible property, broadcasting rights, image rights, and other associated trademarks. Then it is something also which concerns with joint ventures to conduct an event and so on. So often we see that so many corporates, so many organizations come together and conduct an event, and they conduct this event pursuant to a joint venture agreement, and under this joint venture agreement, some kind of disputes might arise between the parties. Now, to understand sports law, we need to understand, as I was saying, we need to know the industry. And the central to this industry is a concept of NSF, National Sports Federation. And for different sports, there are different national sports federations. So for an example, for cricket, we have BCCI. For football, we have All India Football Federation. So a particular sport, there is no regulation as such, which governs all the sports at the national level. Each and every individual sport is regulated by its own federation, and mind, these federations are not government federations. Okay, these are private federations. Now, these federations, in order to conduct the sporting event in the country, organize the sporting event in the country, as well as regulate the sporting event in the country, requires three kinds of recognition. One is of ISF, International Sports Federation. Then at the Asian level, when we talk about India, Asian Sports Federation, and then Ministry of Youth Affairs and Sports. So once we say BCCI is recognized by International Cricket Council, it is recognized by Asian Cricket Council, it is also a member of the Asian Cricket Council, and it is also recognized by the Ministry of Youth Affairs and Sports. One can say that BCCI now can regulate the cricket in country. There's a judgment, if you know, that BCCI is not a state, and therefore one cannot say that if fundamental rights are violated by BCCI, you cannot move the constitutional court. So that was the significance of that decision, whether BCCI is a state or not. But my idea here is to emphasize sporting federations. So sports are not organized by the government itself. Sports are primarily organized by private players, by the private bodies, which are again affiliated to international bodies, which are also private. The role of the government is very limited, and that's why we would see later on that the jurisdiction of the courts, of the national courts, by and large is excluded from the sporting disputes. Only in the very limited number of cases a matter will come before a national court which involves violation of the sport laws. Okay. So these national federations then also in turn recognize state federation, and these state federations recognize district federations. Now, just to understand, because if we have to understand dispute resolution, first we should be able to visualize what kind of disputes will arise, right? And what kind of transactions take place between this industry. One major form of transaction which takes place between these industries, between the sport federation like BCCI and a private organizer, right? For an example, any league, there are so many leagues presently, as I showed you in one of the earlier slides, right? Say for an example, Indian Badminton League. Now, Indian Badminton League, sometime, usually leagues are to be sanctioned by the sporting federation. So for an example, IPL is sanctioned by the BCCI. Earlier, there was an attempt to start Indian Cricket League, ICL, but that didn't succeed because it didn't have the blessings of BCCI. BCCI used its coercing machinery. It said that if you take part in ICL, you will not be able to take part in IPL, you will not be able to represent country in any of the tournaments, or you will also not be able to represent the Ranji Trophy or other kind of sporting tournaments, right? So what we are saying that league or any kind of the sporting can only be sanctioned by the NSF. Private players, but sometimes NSFs, National Sporting Federation, may not have a capacity to organize a league, right? So in that case, private players support that league. So for an example, Reliance, Star India, they supported All India Football Federation, and that gave birth to your Indian Football League. Okay, so now there will be an agreement between Reliance, Star India, and AIFF. Under this agreement, some disputes can be resolved, and if this agreement also has a dispute resolution clause in the form of arbitration, then we would see that matter will go to the arbitration. But if such agreement will not have an arbitration clause, this dispute, because it's a commercial dispute, if it's based in Mumbai where Commercial Courts Act apply, then the dispute will lie before the commercial court of that particular jurisdiction, right? Let's try to understand the first case study. PBL started out, so our badminton league, the current badminton league, started out with the name of Indian Badminton League. So like IPL had a predecessor, Indian Cricket League. Similarly, PBL had a predecessor, Indian Badminton League. So sport is only because now Badminton Federation could not organize the league on its own. It didn't have the capacity, it didn't have the expertise. So Sporty Solution entered into a contract with the Badminton Association of India to organize this tournament called Indian Badminton League. The first season generated losses. Now, as I said, sports means money, it means commercialization. So automatically, BI said we have a contract, whether it's loss or profit, you pay our money, right? So in accordance with that, BI said if you want to organize further seasons of IPL, you have to pay the bank guarantee. Sporty could not pay the bank guarantee, and this resulted into the termination of the contract. So just see, the dispute is not something which is peculiar to the sports law. Non-payment of money, non-payment of profit, non-payment of the bank guarantee could arise in any sector, right? But the dispute is why sports law? Because we also need to understand the growth of badminton or the size of badminton, the size of the market, nature of the market. And unless we know the nature of market, the kind of player, the dynamics of the business, we cannot, we can say, prepare our law, surround our law around that particular discipline of sport. And that's why specialization in that sports sector is also very important. Now, other kind of disputes, when we talk about sporting disputes, they could arise under franchisee agreement, right? So for an example, a team or a club participating in the league, it's not just competing in the sport, right? That's just one way. We as consumers of the sport, watching football, cricket, tennis, we see, right, it as a competition. But there is a specific model of the league, there is a specific model of the franchise, and these specific models of the league and models of the franchisee results into the significant revenue streams, right? And every team or club must purchase the right to play in the league. You cannot say we are good cricketers, we are good footballers, I'm a good tennis player, I'm the number one ranking badminton player, so that's why I have a right to play in the league. No, every team or club has to purchase the right to play in the league, and this is formalized by a franchisee agreement. So for an example, if Chennai Super Kings is a franchisee under Indian Premier League, then IPL and CSK has a franchisee agreement, and this franchisee agreement will also have a third party in the form of National Sporting Federation, because being it a regulatory body, that will also be the part of such kind of contract. The franchisee agreement, what are the various issues will govern the franchisee fees. So if the franchisee fees is not paid, it will result into dispute and the matter can go to the court or arbitration. Any revenues that the league must share with the club and vice versa. So these are some of the kind of disputes which will arise in this kind of agreements. Moving further, let's look at a dispute, a popular dispute which arose under franchisee agreement. So we all know Sahara, Subrata Sahara, a guy, a billionaire who spent his later half of his life in the jail. He bought a Pune franchisee and he made a highest bid in the history of IPL in 2010. And when he made the highest bid, BCCI had promised and IPL had promised at that particular point of time that in 2011 we are going to conduct 94 matches. But that didn't happen. They only organized 74 matches. Now, reduction of 20 matches means reduction of revenue, because every match means revenue through broadcasting or some other ways, right? So due to this, Sahara demanded that franchisee fees should also be proportionately reduced. Now you have reduced the number of matches, you reduce the fees. Now BCCI said we will do the arbitration, but they never appointed an arbitrator because of their high-handedness and they delayed the matter for 3 years. But finally, Sahara took a bold decision and they said we are going to withhold the bank guarantee that every team is required to put up every season in favor of BCCI. The moment BCCI saw that Sahara is not complying with the requirement of the bank guarantee, they terminated the agreement, and we all know Pune could not become part of a franchisee, IPL franchisee. It only became part of the franchisee when CSK and Jodhpur team were disqualified because of the match fixing allegations and other allegations. Only then, for a limited time, one franchisee, Pune Super Giants, came, but otherwise the Pune franchisee, which was introduced by the Sahara, could never, move forward with the tournament. So these are the kind of disputes again. So this is again a financial dispute which is arising between the parties, but nonetheless arising in the sporting industry and hence falls within the domain of sports law. Similar disputes which arose wherein arbitration happened. We all know there were 3 leagues, Kochi Tuskers, then we had Deccan Chargers, one of the winners of the IPL, and Sahara Pune team, right? All 3 of them were aggrieved by this particular thing that you have reduced matches from 94 to 74, so the fees must be reduced. All 3 of them said we will not pay bank guarantee, and in all these cases, your BCCI terminated the agreement. Kochi Tuskers took the matter to the court, took the matter to the arbitration, and arbitrator awarded damages worth 550 crore rupees. So there was an arbitration agreement. In the franchisee agreement, arbitration happened and Kochi won this case in 2015. Now, another kind of transaction which is quite common in the sporting events is the broadcasting agreement, right? We are able to see the World Cup because some firm, some company has got the broadcasting rights. Now, it's an important source of revenue, and now broadcasting is also, with the advent of the digital media, with we watching games on our mobile phone, sporting events on our mobile phone, TV. So there are subscription-based platforms like Sony Live, Disney Hotstar, Jio, and then there are startups also, which are getting these broadcasting rights. So these broadcasting rights are attained through a broadcasting agreement. And if there is a dispute pertaining to this, then that is also an issue of the sporting law. Now, there's a difference how these broadcasting agreements are organized in India and in England. So, in English Premier League, clubs own the stadium, so they license the broadcast right. Whereas in India, stadiums are owned either by the government or NSF, like Football Federation or the BCCI or the Badminton Federation. So, the license is given to the broadcaster by the BCCI or by the other concerned sporting federations. So this is also an important point to distinguish that who will be the parties to the transaction, because that will ultimately decide who will be the parties to the dispute. And an important case for which Lalit Modi is still in London hiding from the Indian government is when, without following the tender process, he awarded the broadcasting rights when he was heading IPL to the WSG, World Sporting Group. World Sporting Group, right, they faced a litigation from MSM, which is a Singapore-based company. They were also interested in getting the broadcasting right. Now, Lalit Modi and WSG created an impression to MSM that if WSG has to relinquish its right back to BCCI, then MSM must pay 425 crore. 425 crore for what? For relinquishing a contract which was illegally gotten. Right? So this ultimately 425 crore became bone of contention, and Mr. Lalit Modi had to flee away from the country when the strings were tight around him. So this is again a dispute broadcasting agreement. Now there are certain other broadcasting disputes which do not fall within the sporting law. They fall within the domain of aviation dispute. So for an example, there is always a frequency at which these matches are aired, right? Now, even these frequencies are what we say as licensed. There is a tender process. So if you remember 2G scam, 2G frequency, around that also there was a scam, there was a dispute. So there is also a licensing and tendering process for getting that frequency. Those are the kind of disputes which fall in the domain of aviation law. Similarly, sometime there could be a scenario of competition law disputes also pertaining to the frequency allocation or the spectrum allocation. But that is not within the scope. So, but what I want to tell you, just this broadcasting agreement or the nature of the broadcast could result into a sporting dispute, aviation dispute, or a regulatory dispute like competition dispute. Latter two are not concerned with the sporting law. Then, if you are an athlete, you are a player, so obviously you will sign an agreement with a club, or you will sign an agreement with the NSF, SSF, DSF, or with whatever team. And under the agreement, you have some rights and obligation. Usually the rights and obligation is, okay, we are hiring you, say for an example, for 4 seasons. And in 4 seasons, X amount will be your compensation. But what happened after playing 2 seasons, you decide, now I want to move to a different club or a different team, right? So this gives rise to a dispute, and this is quite common in football clubs, wherein leaving their home city, hometown, a player moved to a club to a different country, they play there, but then they don't feel happy playing in those clubs, and then they again want to come back, and then the club which you joined say, now you have caused us a financial loss, so you have to compensate. If you do not compensate, there will be an arbitration mechanism. Because why arbitration? Because the FIFA statute, all the sporting federation, they are regulated by the FIFA, and the FIFA statute, as we will see later in this session, mandates arbitration and dispute resolution mechanism. Similarly, when an athlete is not able to participate in game due to injury, your club may say you are a loss to us, and that's why we are not going to pay any fees to you. So these are some of the kind of disputes which might arise between team, club, and the player, and these can be resolved usually resolved by arbitration. Litigation is very less common. So while for broadcasting agreement as well as franchisee agreement between NSF and a private organizer, litigation is possible. As far as dispute between team and the players is concerned, usually it is arbitration 99%, which is a specific dispute resolution mechanism. Then sponsorship is also one of the important thing, and sponsorship happens at multiple level. There could be a sponsor of the entire event, say for an example, who is the World Cup sponsor this time. Then there are team sponsors, all of them put their logos, and some player like Rafa Nadal, or say for an example Ronaldo, or for an example like Kohli, they also have personal player sponsors. They have their own, brands whose logos they put on their bats, rackets, or whatever equipments they are using, whatever clothes they are using, and then those kind of agreements also a dispute might arise. So we have an example of Mohammed Salah, an Egyptian national footballer who played for an English club called Liverpool. Salah had assigned his image right to Vodafone in his personal capacity, right? So image right is an IPR right. Egyptian Football Association allowed the use of Salah's image on the outside of the Egyptian national team's plane, right? So the image rights are with Vodafone, but who is promoting it is going to raise a dispute, and the plane was not sponsored by the association, it was sponsored by a telecom giant, WA. So Vodafone threatened an action against the player, against the federation, as well as the private company which sponsored the plane. But finally negotiation happened and the conflict was averted. But what I intend to say, what are the nature of disputes which could arise under sponsorship? Then there are also disputes pertaining to the renewal rights. Say, for an example, you take the sponsorship, you say, we will be the title sponsors for the 5 years. Say, Vivo was the title sponsors for many number of years as far as IPL was concerned, Indian Premier League was concerned. Now, sometimes these sponsorship agreements say that sponsor has the right to extension, or sponsor has the right to get the first priority in extension. It means IPL after 5 years, their managing committee will again reach Vivo and will offer them that you want to again get the sponsor. But sometimes they do not approach the same sponsor and they approach a different sponsor. So this is a violation of a contractual term, right? So this is what renewal rights are about. So there was a dispute between MasterCard and FIFA. FIFA failed to offer MasterCard the first right to acquire sponsorship for 2006 onward, after its existing sponsorship agreement with the MasterCard expired. MasterCard was able to successfully obtain permanent injunction against FIFA from granting the sponsorship rights to any other entity. So finally, FIFA could not continue with any other sponsor and they had to go back to MasterCard and they had to negotiate and sit with the MasterCard whether they are willing to sponsor. Now, they can deny it. In that case, FIFA can move to other sponsor, but not to begin with, especially if there were renewal rights. Then this new concept, emerging concept is coming up of fantasy league. All of us, right, can create a fantasy league. So you think that Kohli and Dhoni should be together, or Messi or Ronaldo should be together. So you can prepare own fantasy league of your own favorite players. And now in these kind of fantasy leagues, the performance of your fantasy league is dependent upon the personal performance of the player, and different points are given to different activities. Say if it's cricket, then how much runs are scored, how much wickets are taken, how much runouts are done, how much catches are taken. So there's a score and individual score of your league makes you a winner or in the ranks, or that's how the rankings or the decisions in the fantasy leagues are arrived. But when you are preparing your fantasy leagues, you are using the name of actual players. So there is a problem of the image rights as well as IP rights. You are also using the trademark name of the actual league. So if you are drawing your fantasy league by merging CSK, Mumbai Indians, Delhi Capitals, etc., then you need to enter into an agreement, right? This will be a licensing agreement wherein you are permitted to use a brand name and also data, because data is also involved. Performance, which player is performing, how much is a data, which is sometimes protected and needs to, a license is required to be taken to use and exploit this data, right? So even these kind of agreements, dispute may arise between the parties. So what I have discussed till now are the commercial sporting disputes wherein there are commercial transactions like agreement between league and fantasy leagues, then sponsorship agreement, agreement between team and player, agreement between club and broadcaster, then franchisee agreement, agreement between NSF and a private organizer. Now we move to other kind of disputes which arise in arbitration, which are peculiar to arbitration, as I mentioned in my introduction. These are anti-doping disputes or disciplinary disputes. These disciplinary disputes could be pertaining to violation of the rules of a sports club or association, violation of rules of a sports federation, violation of the rules of an international sports federation. So even at be the club level or be the international level, if you violate the rule of the game, there can be a disciplinary action against the person, and against that disciplinary action, there could be a disciplinary arbitration. Let's understand doping disputes. So doping is the practice of consuming or using a substance that artificially enhances the performance of an athlete. Doping is governed by the UNESCO convention called Convention Against Doping in Sport. This convention came in 2005. This convention is supported by a set of mandatory rules which were introduced in 2015. They are called World Anti-Doping Code. These rules govern the set of conditions in which sports are played around the world. So these are, we can say, in the nature of transnational rules, because they are not created by any country. Now this code, World Anti-Doping Code, is organized, is administered by agencies. There is a World Agency, World Anti-Doping Agency, and then there is NADA, National Anti-Doping Agency, right? And the code mandates that there shall be an arbitration of disputes surrounding an anti-doping violation before the CAS in Lausanne, Switzerland. Now, in a very normal way of saying, I've said arbitration. But just see, arbitration as a dispute resolution mechanism, as we understand, it is premised on the consent of the parties. It is premised on the party autonomy. But in a doping dispute, you might not consent to the arbitration. Furthermore, arbitration, as I also mentioned in my introduction, is specific to the commercial dispute. Right? You usually resolve commercial disputes or disputes arising out of legal relationship. These are the two terminologies which are used under UNCITRAL Model Law of 1985. These are also the terminologies which are used under Indian Arbitration Act of 1996. But CAS disputes, Court of Arbitration for Sports, in that context expands the scope of disputes which can be administered by arbitration. So in this way, we have to understand that when we talk about arbitration under Arbitration Act, that's commercial arbitration, and that's not the only kind of arbitration. So there could be an arbitration for doping disputes, which is in the nature of quasi-criminal, which is an ethical issue, can be arbitrated by a private player. Similarly, just to give you a context, that disputes are not necessarily always commercial, and again, under Arbitration Act, there cannot be an arbitration without an arbitration agreement. Strictly speaking, there is no arbitration agreement in doping dispute. You are doing arbitration because you are bound by the rules of the club or the federation you are playing, and the rules of those club or federation or the sport which you are playing. So for an example, if I am playing Olympic, Commonwealth game, Asian game, national game, their rule says that I have to follow a dispute resolution process called arbitration, right? So this is what it is about. Now just imagine even Indian dispute, Indian athlete all involving doping by the Indian athlete has to go to Switzerland. Obviously, there is a mechanism at the NADA also. But if you are not aggrieved, if you are aggrieved by the decision of NADA, you have to go to the CAS in Switzerland. And there are some cases of the sporting event where the direct, if especially when the international athletes are involved, wherein you can directly invoke the jurisdiction of CAS. So this is problematic in the sense that national courts do not have any role to play, do not have much say in this kind. Even if they exercise jurisdiction, CAS has more power than the national court. So in India, we have Indian Anti-Doping Rule, ADR 2015. There are 3 stages of adjudication. First, there will be a panel, which is Anti-Doping Disciplinary Panel. Then there is an appeal. And then if you are not satisfied with the appeal, go to CAS in Switzerland. For international athlete, as I was mentioning to you some time back, you can directly go to the CAS. You can directly go to the Lausanne, Switzerland, and resolve your dispute. So just to earlier some time back, I was telling you about consent to arbitrate. So let me give you some more perspective as far as consent to arbitrate is concerned, because this is one of the contentious issue, right? For an example, you are a swimmer, and in your as a swimmer in your district, there is only one swimming pool, and around that in that swimming pool, there is a district water polo association which governs who are the people who can become members, who can swim, what time, what rules, what regulation, all will be by the association, right? And say this association organize some competition. Now, if this association has to organize some swimming related competition, it has to take permission of State Swimming Association. And State Swimming Association is bound by the Swimming Federation of India. So even when you are playing a water polo event at a district level, doping code or the doping regulation of the State Swimming Association will indirectly apply to you. Now, you might not come across, you might not realize, you might think I have nothing to do with the State Swimming Association, forget about Swimming Federation of India or the international federations, right, or CAS. So that is why it is very important for the athletes to be diligent. So one important aspect of the sports law is also about awareness of the sports law to the athletes, telling them that if you take part in this competition, there are many rules and regulations to which your association, District Water Polo Association, is bound by because of their membership with the State Swimming Association, and State Swimming Association is in turn bound by the Swimming Federation of India. So just see a chain or hierarchy in which one's individual athlete will be bound by the rules onwards and upwards. Now, the rules of the Swimming Federation of India require arbitration of dispute between its member and for violation of the competition rules. So, if you violate any competition-related water polo dispute, arbitration can happen. A person who become member of district association is bound by arbitration. You might say now, right? As it is it's a very usual argument in commercial that, you know, I'm taken out by surprise. You never told me that I have to do arbitration. And if you look at the judgment of MR Engineer judgment very specifically say this would have been a commercial dispute, party could have never been referred to the arbitration, because if the arbitration agreement is contained in the standard industry term, then as per para 12 of the MR Engineer, specific reference must be drawn to the arbitration agreement. But this is not a case in case of sporting rules or sporting events. And that's why sports arbitration is very different from the commercial arbitration. As I mentioned earlier, there is no arbitration agreement which is required, point number one. Point number two, even if I say there's an arbitration agreement in the rules of the association, as per the para 12 of the MR Engineer judgment of the Supreme Court, specific reference to that arbitration agreement is not required. And then also the nature of dispute, like anti-doping disputes, make sports arbitration altogether a different ball game. Similarly, football clubs that participate in the I-League, they require their footballers to bind themselves to arbitration clauses in accordance with FIFA Statute 2019. I-League is an Indian league, okay, Indian football league, in which players can participate. There are different clubs and you can become members of those clubs as per the agreements which we mentioned. So the moment you become member of that club, so you think you have only signed an agreement with the club, but the moment you sign an agreement with the club, you become bound to the FIFA Statute of 2019, because that club is bound by the National Federation and National Federation is bound by the FIFA Statute. So these indirect application of laws in sporting arena is one of the biggest challenge. Then what is the role of the national court? And this is something which I'll again explain through FIFA statute. So if you look at the article 59 of the FIFA statute, it says CAS is the Supreme Court of football. So who is Supreme Court of India? They don't know. CAS, which is based in Switzerland, which is created, which applies Switzerland law. Again, CAS is not an agency which applies transnational law. So somebody was referring in the chat box about transnational sports law. CAS does not apply transnational sports law. They apply laws of the Switzerland. They apply Swiss Private International Act. Okay, but still it is a Supreme Court of football around the world, right? So it precludes, as I mentioned, recourse to the apart from very limited recourse to the ordinary court of the law. So just imagine a private body taking out the jurisdiction even of your Supreme Court, High Court and District Court, whatever you want to say. And 59 FIFA statute also dictate that national association ensures that disputes are resolved by way of, so again, arbitration is specified as a dispute resolution mechanism. FIFA further enhances the rule of resolution of soccer disputes in the statute, Article 15.f, where it says all relevant stakeholders must agree to recognize the jurisdiction and authority of CAS and give priority of arbitration as a means of dispute resolution. So again, there is a clear mandate of arbitration and you cannot undermine the authority of CAS, though it's a private body. Now, even Indian government, so there is a resolution of 2016, wherein which is issued to all national sporting federation, wherein it is urged that arbitration must be a preferred means of dispute resolution. So, what is CAS? CAS is a private arbitral institution. Arbitration before the CAS are seated. No, again, just think. Arbitration in anti-doping disputes and the disciplinary disputes will go to the CAS. But as far as arbitration, and they will compulsorily go to the CAS, right? There is one way or the other way, they will come to the CAS. But as far as arbitration for CSDs, commercial sporting disputes under franchisee agreement, sporting agreement, they will not go to the CAS. There could either be an ad hoc arbitration or there could be an institutional arbitration through Mumbai Center, ICC, Singapore International Arbitration, LCIA, whatever institution. So you don't have to choose a specialized sporting arbitral institution in those kind of disputes. Though you can use CAS even in those disputes, but therein the jurisdiction of CAS is optional. But as far as doping dispute is concerned and disciplinary dispute is concerned, jurisdiction of CAS for conducting arbitration is not optional. So arbitration before CAS, they are seated in Switzerland. So I hope you understand the concept of the seat. Seat means the juridical seat. It does not mean venue. Venue can be anything. You can conduct the arbitration in India. But seat in Switzerland means the procedure of Swiss federal statute and private international law will be applicable for the conduct of arbitration. You can't say Indian Arbitration Act will apply or English Arbitration Act will apply or Chinese arbitration law will apply. Because the seat is in Switzerland, seat is the gravity of arbitration as famously propounded in the judgment of Balco of our Supreme Court. So, because, and the concept of the seat necessarily denotes that the Swiss courts will have the supervisory jurisdiction. So, the choice of seat is akin to the exclusive jurisdiction clause, though it's a contentious statement, but somewhat accepted statement that the choice of seat is akin to exclusive jurisdiction clause. So automatically, if I say Switzerland is the seat, so automatically Swiss courts have the supervisory jurisdiction, and Swiss Federal Tribunal is vested with the sole jurisdiction to set aside an international arbitral award. So against the award of CAS, you cannot come to your local court, you cannot come to a domestic court and say, please help me, please set aside this award. No, only Swiss Federal Tribunal will govern it. And under Swiss private international law, even approaching Swiss Federal Tribunal can be waived. There is a right to challenge award can be waived. It means even if the player is affected, if the right has been waived, the right to challenge has been waived, then you cannot challenge the award before Swiss tribunal. So even that option will be foregone. So a case study on waiver between CANES versus ATP Association of Tennis Professional, which conducts various tennis tournaments. So there are ATP tours. So now the dispute in this involved a renowned tennis player wherein the allegation was anti-doping. The athlete appealed the decision of anti-doping tribunal on the main contention that the substance he had used had in fact reduced his performance. And CAS partially upheld the award. Athlete approached the Swiss Federal Tribunal for annulment. But ATP approached tribunal and said, you do not have the jurisdiction because our 190, Article 192 says that you cannot approach tribunal. The award passed by CAS cannot be challenged. Now, just imagine that you not able to avail Section 34 challenge under Indian Arbitration Act, right? This will violate a mandatory public policy of the country, and this is one of the criticisms of the CAS as well as Swiss international policy. And in fact, there are many cases, one which the previous speaker was also mentioning about the case of, what was this case? The case of Claudia, a German gold medalist, German Olympian gold medalist, who lost a case at CAS, could not challenge it, but lost the challenge, but then went to the German court and again made a challenge before the German court. Because ultimately, while the CAS statute says or Swiss international law say the German courts may not have any jurisdiction, can you really take away the jurisdiction of a sovereign court? They do not have that kind of coercive power to take your jurisdiction. But they do have one coercive power, which I'll mention to you when I talk about enforcement. So, in this case of CANES versus ATP2, what Swiss tribunal did, yes, we agree. Say, how would I know as an athlete? I'm there to play a sport. I'm there to train my body. I'm there to perform. I'm there to ace my performance and win medals and trophies for my country. Am I supposed to know what is Article 192 of the ATP rules, which say you cannot challenge the award of CAS? Can you make me bound by that? Can you say I have foregone my right to challenge? In the European Convention of Human Rights, Article 6, it will be a complete violation, such kind of provision, right? So recognizing all these facets, Swiss tribunal said, yes, we recognize that there's an unequal bargaining power. You just chose to play tennis. Because you chose to play tennis, you became bound by ATP. Because you bound by ATP, you became bound by CAS, you became bound by WADA, you became bound by NADA. So it's again, there is no choice. You just choose to decide a sport. And that is why a lot of sensitization, a lot of awareness among the sports player is required. Now, the CAS procedure is not different from the procedure in the regular arbitration. Like regular arbitration has a request for arbitration reply, there's statement of claims, statement of defenses, there's an evidence stage, hearing stage, arbitral award stage. the same due process is also followed in the CAS. And CAS acts as a forum of first instance as well as an appellate instance. So if somebody has a grievance against the decision of the first instance CAS, they can also appeal against that decision, right? And CAS procedural rules recognize that CAS arbitration can arise in three situations. Arbitration clause contained in a contract or regulation, so franchisee agreement, which mentions that CAS will be our arbitral institution, arbitration will be under the auspices of CAS, then you can do arbitration as per CAS procedural rules. Or if there is a decision which is rendered by the federation, so for an example, if BCCI decides to expel a cricketer, right, because of the violation of some rule, then that appeal can go to the CAS. Or say football federation, its decision can go to the CAS. Or some association, sporting association, their decision can also go to the CAS. So sport related body, which is a very broad term, sport related, you need not be an association or federation, but if you are anyone, say even a gaming platform, gaming website which violates the rights of an athlete, right, or athlete violates your right, you can go to the CAS and can do arbitration. So there are different ways in which jurisdiction of CAS can be initiated. Now, enforcement is one of the most interesting parts of the CAS, and which in arbitration has received a lot of attention. Now, just imagine if you are doing arbitration, just a commercial arbitration, even if you have got the award in your favor, right? In order to enforce the award, if the award is obviously not voluntarily enforced, you have to use the machinery of New York Convention 1958, and if you are in India, you have to use Part 2 of the Arbitration Act, and your decision, your award will be enforced by the court. It means the court will see whether the award which has been passed is according to the public policy or not. Okay, and if the award is against the public policy of the country, then the court may say we will not enforce the award. But this is not a possibility under CAS. In fact, CAS does not require the support of the national court or the government for the purpose of enforcement. Say, for an example, you are a football player, and as a football player, you joined a club. Now, when you are a member of a club, you violated an agreement of that club, okay, and the matter went to the CAS. CAS passed a decision against an athlete, okay. Now, in order to enforce its decision, the CAS will only tell your national sporting federation to enforce it. How it will enforce it? They will just simply say, expel this athlete, ban this athlete. This athlete will not be able to take part in these events. This athlete will have to pay a compensation of this event. And if this is not done, say for an example, NSF, say National Sporting Federation, says we are the boss, who is CAS, who is some private body sitting in Switzerland to dictate that we should take these decisions. What CAS will simply do, CAS will tell the international body to remove your, what we say as recognition. Now, because your recognition is removed, you will not be able to take part in the international events like Commonwealth Games, Olympic Games, international tournaments like Football World Cup, Wimbledon, Cricket World Cup, or any kind of championship. You will not be able to take part. So, what is there? There is a pressure tactic as an enforcement mechanism, and if as a sporting federation you say I'm not willing to enforce it, then they will just remove you. They will just not recognize you, and not recognizing you also means all the athletes which are affiliated to that sporting organization will not be able to play sports. So pressure will also come from those athletes. Bhai, aap us athlete ko nikal kyun nahi rahe? Why are you not removing that athlete? So that is why it is called a self-enforcement mechanism. And because of this, Sports arbitration also falls in the domain of transnational arbitration. Somebody was asking about transnational sports law. I don't know whether transnational sports law will be a possibility, but as far as enforcement is concerned, sports arbitration is transnational because it is delocalized. For the purpose of enforcement, it is not dependent on any national court, or it is not dependent on anybody. It has its own mechanisms of disqualifications and disincentivization by which it will enforce the decision. I think that's the end from my side. Thank you so much. This is a book which was edited by me and my colleague Yashraj, Specialized Arbitration. It has a big component on the sports arbitration. There are 4 to 5 chapters written on sports arbitration, so you can understand all the issues which I have discussed today through this book. Thank you once again to the Sports Law, newly inaugurated Sports Law Center, Center for Intellectual Property, and all my colleagues.
Thank you so much for the wonderful session, Professor Chirag Balyan. So, if there are any questions, you may ask now.
Good evening, sir. This is Atri speaking.
Yes, Atri. You are from which? Can you introduce yourself first?
Yes, sir. I'm a third year law student at Indian Institute of Management, Rohtak, pursuing BB LLB.
Okay. Yes, Atri.
Sir, I would like to know the scope of jurisdiction of the Competition Commission of India with respect to how the individual sports bodies operate. Specifically, in the example that you cited, where the BCCI did not allow the teams who were taking part in the ICL to take part in the IPL. So, does the jurisdiction of the CCI extend to such matters?
No, the jurisdiction of CCI does not extend to these kind of matters. Because as I mentioned in one of my earlier slides, there's a 3-stage recognition. You need to be recognized by the regional body, say for an example, Asian body, international body, as well as your concerned ministry. And these are not the kind of cases wherein allegation of monopoly or cartels are being raised, because technically speaking, that there should be one body only which must be regulating the sports. If within that umbrella body you want to create your club, you want to create your agency, you have to go through that particular channel. But yes, you are right, a strong argument can also be made against that these sporting federations are non-functionals, they are not competent in one way, and some other people must also be having the right to approach international federations and seek approvals and registration. So in that context, one can make a case, but I'm not, sure how much it will be upheld or how much it will be recognized. But it's an interesting case to be made, or an argument to be made. Similar kind of situation, also arises in the case of copyright law. In the copyright law, for the purpose of royalty disbursement, there is only one society called Copyright Management Society. And all the royalties, everything, whomsoever, whatever industry is monopolized by the Copyright Management Society. And in the past, some of their activities have also raised concern that they're abusing their market position, because to invoke competition law, you have to also invoke the argument of abusing the market position. At the end, it is a statutory body, and those arguments didn't found much way. So it's not just in the sporting arena. What I intend to say, other branches of law, you would find such kind of example wherein some kind of monopoly has been vested in one body, even though they're abusing that, they are not able to perform. Competition Commission haven't ventured into these kind of issues.
Thank you very much, sir.